Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3069. United States of America versus Cesar Gomez Almonte, also known as Johnny Gomez, also known as
and collectively denied Mr. Almonte's fundamental right to a fair trial. Proceeding on to what we believe is our strongest argument, Judge, is the venue argument. The government proceeded to try this case in the District of Columbia based on 18 U.S.C. 3238. The venue lies on the district where the defendant is first brought is something that was ignored by the district court. In this particular case, Mr. Almonte had two co-defendants, and the bulk of the cases had originated from the Southern District of Florida. In fact, there were over 25 other defendants that were indicted and tried in the Southern District of Florida. Trial counsel focused on the fact that these cases stemmed and originated and made objections to venue based on the fact that substantial acts occurred in Florida, the vessel that was intercepted off the coast of Miami, and co-defendants were all tried in Florida. However, the indictment on which Mr. Almonte was, the charges on which Mr. Almonte was tried were based out of DC. Now, in the district court's review of the venue argument to establish whether DC was correct, the DC court was not submitted or was not provided with all the information needed to make a proper analysis of whether the DC court was the proper venue. In evaluating the venue, the DC court just reviewed and looked at the fact that Mr. Almonte and Mr. Rodriguez were both indicted in the District of Columbia. However, when a motion to dismiss was filed during that hearing, the district court made a determination that venue was proper based just on the fact that the indictment had taken place in the District of Columbia. However, the government omitted the fact that there was a third defendant, and that defendant was in fact first brought into the Eastern District of Virginia. The government has conceded that point, but however, at the pre-trial stage, they did not inform the court of that issue, and the court made an improper determination based on the facts before it that venue was in fact correct in DC. If the court had been provided with the accurate information and the fact that Mr. Zaria was apprehended and brought to the Eastern District of Virginia, and that he was a co-defendant and was first appeared in that district, that would have made venue in the Eastern District of Virginia the proper venue, not the District Court of Columbia. Furthermore,
you know what the phrase joint offenders means, how it's been defined?
Yes, Your Honor, and there's no actual there's no actual dispute as to whether or not he was a co-defendant because the government has conceded that in their brief. And in fact, in the middle of the trial.
With respect to the people in Florida.
Well, that argument never, the court didn't address that argument because the argument was that they were going to try him under Section 3238, and therefore, although Florida was a proper and the best venue where this case should have taken place, the vessel was apprehended there, the narcotics were confiscated there. The government decided to take him to DC. At that point, they relied on 18 USC to make that venue, well, which clearly seemed to be a forum shopping. They decided to bring him to DC. However, they failed in that attempt because instead of just following the indictment and having him indicted in DC first, they first brought Zari, one of the co-defenders, to the Eastern District of Virginia. At that point, their a fallback venue at DC no longer applied.
But the district court became aware of this, and defendant had an opportunity to make that argument and persisted with the argument that the proper venue was Florida. And then finally, at the very last minute, district court said, you've waived it. You've been given the opportunity several times and you didn't take it.
Well, I think the argument there, the trial attorney did focus on Florida, and that's correct. However, venue was originally challenged pre-trial under Rule 12, and that once defendant challenges the venue, is up to the government's burden to establish that's a proper venue, and establishing whether it was the government's.
The government eventually, in a timely moment, conceded that Virginia was the proper venue, and the district court said to the defendant, "I think you might want to raise this," and defendant didn't.
Once defendant raises venue, I think the obligation.
You're just saying there's a venue claim, that's it, and then that remains enough to encompass all possibilities thereafter?
Once I would argue that venue was challenged, and once venue is challenged, the burden is on the prosecution to establish whether that's a proper venue. The district court did not have all the information when they made their analysis.
What I'm saying is, as I've understanding the record, when the government did become aware of the Dulles discussion and realized that Virginia was it, the government didn't resist that. The district court didn't either, but the defendant did.
Well, I would say that
the defendant did not want to be in Virginia. The defendant wanted to be in Florida, and the district court said no.
That's accurate, but I think the venue still must be established. The burden is still on the government to establish that. Even in the district court level, the judge said it was an unusual situation that he had been placed in because the issue did not crystallize until the trial, even though it could have been crystallized before.
Right, but then it did crystallize, and it was still time for the objection to be acted on, and you resisted it. The defendant resisted it.
It wasn't a resistance.
It didn't bite.
It was a focus on Florida, but that's not a resistance. At that point, either way, it shifted the burden back onto the government to establish it. And at that point, the government is who misled the court.
Here's a scenario that comes across in the record. District court says, now based on all of what I'm seeing, the proper venue is Virginia, to which defendant says, I want to be in Florida. And that colloquy occurred several times. That's a waiver. The district court's making it very clear. Do you want to raise that objection? And the defendant persisted in saying, no, I want to be in Florida.
It was eventually brought up, but the idea that venue would even come up at that moment, if venue was properly vetted and the application of 3238 would have taken place at the pre-trial stage, the court would have agreed and granted Mr. Almonte's motion to move it to the Eastern District of Virginia at least. But that didn't occur because the court wasn't aware that Zari was brought into the Eastern District of Virginia, neither was the defense. So at that point, all they had was a bunch of redacted documentations that didn't make it clear until.
When you say that the court and anybody else was unaware that Zari was brought to the Eastern District of Virginia, do you mean that they were unaware that that the unnamed person was brought to the Eastern District of Virginia, or a person named Zari? Because I thought that actually it was known that the co-defendant was brought to the Eastern District of Virginia, but just didn't know his name.
Right.
They didn't know his name. There was a co-defendant, but in this case, there were 25 other defendants. Some of them, and all that information was provided to the defense. So all the other 25 defendants that were tried in the Southern District of Florida could have been one of those folks that were brought into the Eastern District of Virginia, was unknown until the testimony fleshed out the fact, and that was the first time the court was aware of it. And the defense made it clear at that point that they filed that mid-trial, the court actually removed the waiver because the court at that point readdressed the issue and therefore vacated any possibility of a waiver, readdressing the issue of venue.
Mhm.
So we would argue that the burden was misplaced and the district court failed in shifting the burden back into the defense when it was the government who failed to provide that information to the district court when they were making their initial analysis as to determining whether Virginia or DC was the proper venue.
Are you aware of cases where this has happened? I mean, the government knew since before the indictment in this case that Eastern District of Virginia had to be the right venue because they knew about Zari. They knew he was going to be your co-defendant, and they didn't say a word. They just came to DC. On the other hand, so they knew from, like I said, pre-indictment, they knew, and didn't say a word until things started getting uncovered mid-trial.
Right.
But then, as Judge Edwards was saying, when you were invited to argue, the counsel below was invited to argue that EDVA was the right venue, that argument was made. It seemed like he just wanted to be in Florida and didn't care about the venue in EDVA, and venue can be waived. So I'm just trying to figure out what we do with the fact that the government knew from the very outset and so did not fulfill its duty and its burden of proof as to venue from before the trial even started. So every minute of that trial, the government was responsible for being in the wrong venue, and knowingly so. On the other hand, given the opportunity, you waived it. So your argument is, the burden's on them, and their argument is you waived it, and
Well,
I don't know what they
arguments.
waived by not raising the issue. I'm just trying to sort it out because I haven't seen one that has this type of fact.
I mean, we stick to the case laws that we provided, and Lam Kong, while they determined that the burden is on the government to establish venue, that the jury must be aware of that, that the jury was brought to, the burden is on the government to prove every charge and that the venue is proper.
They had to establish it, and they conceded that they were wrong.
They did, and the issue was whether it was waived, and we don't argue. We argue that it wasn't waived since venue was challenged from the beginning, and since it was consistently challenged, whether it was the Southern District of Florida or was in the Eastern District of Virginia, the venue had been challenged from the onset. So it's not like other cases that were cited that there was no mention or there was a clear waiver. Here, venue is being challenged. The defendant is not under the position that they have to establish all the areas where venue is proper. Neither the government concedes that they also rejected that Florida would be the proper venue because there was other places that the case could be tried. And in their attempts to take the case and forum shop it and bring it to DC, they also withheld information that would have clearly been instrumental in establishing that DC was not the proper venue. In fact, the Eastern District of Virginia.
Yeah, I haven't quite seen this in the cases, but tell me, so is your argument, if you have cases that makes this proposition that the defense's only burden is to say venue is not in DC, and then the government has to affirmatively prove that it is proper in DC. And so whether you were saying Florida or not, you were saying not DC. And in response to your not DC, the government conceded not DC.
Yeah. I think at the
Is
end
that
of
how it works?
that is a correct.
Say what is the proper venue?
I don't think that the obligation is to determine which is a proper venue, just to challenge venue, and they did challenge venue. I think the burden continuously shifts once you challenge venue back to the government, and the government failed to provide all the information necessary for the court to make a proper determination as to which is the correct venue. Once the court was aware of it, again, venue was challenged. It was mid-trial. At that point, any waiver issue shouldn't take place anymore because now the court reopened the issue. So the waiver argument shouldn't stand. And additionally,
Would that apply? So suppose this happens, that everything proceeds in that way, and then the court just engages in a direct colloquy with defense and says, look, you've been making a lot of arguments so far that the proceedings should have gone on in Florida. Now that we have all this information, we see that actually there's a very good argument that the proceedings should happen in the Eastern District of Virginia, not in DC. We're all in a courtroom in DC. So I'm asking you, the defendant, if your choice is between DC and EDVA as opposed to DC and Florida, let's take Florida off the table, and your choice is between DC and EDVA, are you okay with going forward in DC? Do you waive the opportunity to go to EDVA? If the defendant says, yeah, if that's my choice, if I have to be between EDVA and DC, I'm fine with just proceeding in DC. Would you say at that point that that can't happen?
Well, I don't think I don't know if the option would be to remain in DC at any point. I mean, I guess the defense could have waived it and said, we prefer to stay in DC. That's
Right.
not, I guess, the argument if that would have come up, clearly the defense was never happy with staying in DC. And even if that would occur, I think that it would be there is a scenario, I suppose, that that this could be a waiver and they knowingly say, I'm going to stay in DC, but that's not the case here. The case here just from the onset was being challenged for venue. And
If that's true, then all I'm saying is that it's still possible to waive even if an objection to venue is made. Even if your understanding is right, that all one has to do as a defendant is object to venue to say that this is the wrong venue as opposed to then going on and saying which is the right venue, which I understand your argument to that effect.
Mhm.
Once the defendant has done that and flagged the venue issue, it seems like it's still possible to waive an objection to the current venue.
I would think that it would still be an improper venue in DC. The proper venue as written by statute in the Sixth Amendment right to a trial would kick in, and it would still be the Eastern District of Virginia. There was cases that were cited where there was a waiver because the defendant never brought it up, even though it was brought to their attention. I think it's not the same scenarios here because they waited to after trial to make that determination. And here, Almonte continuously challenged venue throughout the entire process, even through the trial, and then was admonished for it. The court said not to bring it up anymore. So venue was constantly being challenged, and that's what distinguishes those cases from here. But I think the proper venue, no matter what, should have been the Eastern District of Virginia. Well, theoretically, should have been always Florida, Southern District of Florida. But a calculated attempt to forum shop and bring it to DC failed when they originally first brought Zari to Eastern District of Virginia, and they try to clean it up by stating that it was a Rule 12 violation and it wasn't brought to the court's attention, although venue was challenged pre-trial. So they met their burden on the Rule 12 again during the trial, and in that hearing, the court dismissed any possible argument and said, based solely on the indictment, although the government knew all along that Zari was brought into the Eastern District, they didn't mention it during that process and during that hearing. And it wasn't until it became obvious to all parties that during the trial that it resurfaced, that an argument was remade. So I still think that, the best thing to do is to vacate. The government clearly misled the court into making a determination, and in their analysis to establish the wrong venue in all their attempts, they never cleared it up. And at the end of the day, they just blamed the defendant and shifted the burden back onto the defendant.
If my colleagues have questions on any of the other issues, not, we'll give you a little bit of time for rebuttal.
Thank you.
Thank you, counsel. Mr. Lang.
Good morning, Your Honors, and may it please the court, Andrew Lang for the United States. The district court correctly denied Gomez-Almonte's speedy trial clause and venue-related motions, and its inquiry into the jury after learning about a comment about defense counsel was not an abuse of its considerable discretion, and this court should therefore affirm. I'm, of course, happy to jump straight into the venue issue. Gomez-Almonte makes two arguments about venue on appeal, one of which he has been making throughout the course of this litigation, starting prior to trial, and the other of which he never made until his written Rule 29 motion and now advances on appeal. So starting with
Do you have any case that says the burden is on the defendant to identify the right venue once they make a venue objection, or they just have to say venue here is wrong? That's sufficient.
I don't have a case specifically for that proposition, Your Honor, and I suspect That's because this scenario is somewhat unusual, where there are multiple different districts where a defendant is arguing the case should have been venued, and one of those districts doesn't
Let
emerge
me ask
until
you
later
another
on.
way. Does the government have the obligation and to establish proper venue, to bring the case in a proper venue?
Well, ultimately, yes, of course, it is the government's burden to prove venue
So
by
in this case,
preponderance.
the government knew pre-indictment. It was in the wrong district. The government had all the information and it knew. And it conceded before the district court. You're right, it doesn't belong here. So it's known. It made a deliberate decision. And then it conceded it during trial. And throughout trial, even pre-trial, Almonte was saying, venue was wrong here. And he was arguing for another place, but I'm just trying to understand why him misunderstanding where it should be matters. Government has a burden. Government knew. Government didn't care. Government concedes. Venue objected to repeatedly. Why isn't that reversible error?
Well, I have a number of thoughts on that, Your Honor. The first of which is, I think the application of Rule 12 is important here in terms of determining whose burden it is to do what. So the defendant has to raise any defects in the indictment if the basis for raising those defects is reasonably available prior to trial. Sometimes indictments are defective.
But the government has a pre-existing obligation to establish proper venue.
Well, and I don't dispute that.
The government knew it wasn't. I mean, this is not a case where it was a surprise to the government.
Well,
Some other external factual development changed things. Why are we pointing at the defendant for not doing things right when the government was wrong from indictment forward and admits it?
well,
Why should he bear the burden of that?
A number of responses, Your Honor. So first of all, again, I agree, as I think we made clear in our brief, that venue was proper in the Eastern District of Virginia. My understanding from speaking with the trial team, although of course I wasn't in the room during the charging decisions, is that this was an honest mistake. The narcotic and dangerous drug section often brings these kinds of cases in the District of Columbia, and I don't think they appreciated the significance of Zari having been brought to the Eastern District of Virginia. In terms of when the government made this concession, I don't know that the government immediately knew that venue was improper in the District of Columbia. So for example, at Supplemental Appendix 1275, in response to the district court's request for briefing on this very question, the government reiterated its position that venue was proper in the District of Columbia. So I don't know that I would characterize this as a knowing.
Okay, the government had this is not the hardest legal question anyone grapples with. And you were arguing about the statutory provision all along, just in response to the Florida arguments. But you all were looking at that statutory language and briefing it and talking about it. But also, the government, I'm not suggesting any willfulness or maliciousness here.
Of course.
But it had all the facts and all the knowledge. It brought Mr. Zari in and then said, this is co-defendant 3. This guy we brought into Virginia, and looking at the statutory language. And so you're going, well, we made an honest mistake. Well, maybe he made an honest mistake, but you all made the first one and you brought the prosecution. You have the burden. And you've admitted, it's just you had the burden. You made the mistake. Let's just say yours was just as honest as his was. And you conceded we're in the wrong jurisdiction under this statute. You didn't have an argument. It could have been either EDVA or DC.
That's correct.
It was wrong.
I agree.
And so I'm just understanding I'm having trouble understanding why, we've got both problems on both sides here. And if they're all good faith problems, why does it fall on the defendant when the government has to do this up front? Is the first one that has to do this?
Well, I don't think there's very much in Your Honor's question with which I disagree. This was a mistake that the government ultimately bore the burden for because it brought the indictment in the first place. It's responsible for proving venue. But ultimately, here on appeal, we have to view this error through the lens of Rule 12, and we have to consider the fact that not only does Rule 12 apply, but Gomez-Almonte affirmatively waived his argument that venue was proper in the Eastern District of Virginia when he was invited by the district court to make that argument. And as Judge Edwards pointed out, he declined to do so. Instead, he repeated his argument that venue was proper in the Southern District of Florida. As I understand my colleague to have acknowledged, that really was the sole focus of defense counsel before the district court, contending that because the conspiracy's goal was importation into Miami, because some overt acts may have occurred in the Southern District of Florida, because other defendants may have been indicted in Florida, that was the locus delicti. That was the place where the indictment should have been brought for everyone. But as we explain in our brief, that argument is incorrect under Section 3238, and that is the argument on which the defendant was hanging his hat at trial. So because he affirmatively waived his opportunity to make the argument about the Eastern District of Virginia, and the district court, I think quite appropriately, dealt with that argument by saying, well, it may have merit. There may be something here. I'm just realizing this now. Invited briefing. I think the district court handled this unimpeachably. The parties briefed this issue, and Gomez-Almonte declined to make this argument.
Once the government concedes, we're in the wrong courthouse. So we'll jump ahead to the briefing point, and none of this is a criticism of the district court judge. But once the government concedes we're in the wrong courthouse, why isn't that enough by itself? Why does it matter? And the defendant keeps saying it shouldn't be in DC. It shouldn't be in DC. Because the second clause of that sentence is I want it in Florida, but definitely saying it shouldn't be in DC. He said that from the beginning, from the get-go. Shouldn't be in DC. Government agrees it shouldn't be in DC. Why doesn't it all just stop there?
Two
Why do we
responses.
care what he briefs?
Two responses, Your Honor. First, again, I'm not sure that the government did concede that the case shouldn't be in DC. Again, in its supplemental filing in response to the district court's request for briefing, and again, I believe that's supplemental appendix 1275, the government reiterated that it believed venue was proper in the District of Columbia. On appeal, of course, we agree that that was based on a misapplication of Section 3238, but I don't know that the government immediately or ever before the district court conceded that venue should have been in the Eastern District.
What would have been the argument under the statute? It's plain as can be when the first offender is brought into the country, where they land, where they're arrested and brought. That was all EDVA.
I couldn't agree with Your Honor more. That's not the argument that the government made in the district court. The government continued to argue that venue is proper in the District of Columbia, but I read the statute the same way that Your Honor does. But that having been said, as I mentioned a moment ago, I think there are a number of procedural hurdles here. Even if Gomez-Almonte hadn't...
When the government conceded post-trial, do you agree on that?
I'm not sure when it would have done that, because the argument about the Eastern District of Virginia was only ever actually advanced by the defendant in his written Rule 29 filing, which was filed about a month after trial had concluded in December. And then the district court only heard argument about that at sentencing and held, you've waived the argument, it's too little too late.
Did the government file a brief in response?
I don't believe the government conceded at that point, but I don't have that filing in front of me here.
All right.
But in any event, I think certainly by that point, the district court had a very solid foundation for finding waiver, in particular because of the affirmative decision not to pursue this argument at all after being specifically invited to do so, but also through the operation of Rule 12's waiver absent good cause, or in the alternative plain error, which we discuss in our brief.
Are you aware of any case, because I couldn't find this too, and I sure could use some help, because again, it seems to me the defendant's only burden is to say venue's improper. It's not their job to tell you where to bring your case. And he was saying that. There's no one disputes that he was saying that, including Rule 12 and all through trial and post-trial. So when he didn't argue EDVA, when he didn't tell you where your case belonged, how did he waive his objection that it doesn't belong in DC?
Well, first of all, I wish that I could provide Your Honor with a case directly on point. I haven't found a case where there were multiple legally distinct objections to venue and one was made and the other was not. That having been said, I think applying the general rules of waiver here makes perfect sense because the defendant was presented with a specific argument and declined to make it.
But he was asked, the specific opportunity he was given was to argue that EDVA was right.
Yes, I agree with that.
Why? you know a lot more about criminal trials than I do. Why is that the defendant's, I mean, what are you waiving? Because I don't, if he had said in response to that motion, I don't know where it belongs, but it does not belong here. Would that have been a waiver?
Well, it might depend on the basis for the objection. And I
In this
take,
very case, instead of saying Southern District of Florida, he said, as I've said from day one, this case does not belong in DC. I don't know I'm not going to tell the government where it should be.
I think, although that would be a closer case, I think if he had said that in response to the district court's invitation on this record, that probably would also be a waiver
And
because
that
it would,
assumes that your waiver argument assumes that there's an obligation on the part of the defendant, not just to object to venue, but to identify and argue why another place is proper venue. I mean, you could have a situation where there's just no venue in the United States.
that's,
And, you know, and if, like, that's why I don't understand if his argument was, it's not my job to tell the government where to bring this, that would be proper venue, because I don't think it is. I don't think anyone thinks it is. Then, as long as he was saying it's not DC, why did he waive it by not saying where it should be?
well, two things, Your Honor. First, let me address waiver in the sense of an intentional relinquishment of a known right. And second, let me address the preservation of the issue more generally. So first of all, with respect to waiver in the Zerbst sense of intentional relinquishment of a known right, I think the authority that we have available to us is pretty clear that when a defendant is specifically offered an argument and says, no, thank you, that is intentional relinquishment of that argument. With respect to preservation more generally, in terms of what a
Can I
defendant.
follow up on relinquishment?
Oh,
real
please.
quick? I want to make sure you get to make that point too. Relinquished. What did he relinquish?
The
He still said not DC.
the right to make the argument specifically that Section 3238
Okay, but if he didn't-
required.
If he had
venue.
no obligation to make that argument beyond saying DC is wrong, he didn't relinquish or waive anything.
Well, I don't know that I would use the word obligation, but when a district court says, in effect, would you like to make this argument? And the defendant makes a different one. I don't think there's any way to interpret that other than intentional relinquishment of that argument. And this court has come to a similar conclusion in other contexts, at sentencing, for example, when a defendant declines to make an objection that's obvious on the record, that constitutes waiver.
I mean, it seems to me that if the way it works is all the defendant has to do is object to DC and not have to specify which the right one is, that let's just suppose that that's correct. Me, one can imagine a situation in which the defendant's decision on whether to raise that objection or to waive that objection depends on the answer to where it would go forward. So I mean, the defendant can decide whether to waive or not. And it could be that the defendant raises the objection and says, I don't want to, I don't want to be DC, but DC is the wrong venue. What's the right venue? I'm not saying. DC is the wrong venue. And then if there's a further elucidation of the issue, and then it turns out that the right venue is the EDVA, I think at that point, the defendant can definitely say, well, if that's the right one, I waive my objection.
I believe I agree with all that, Chief Judge Srinivasan. Yes, I think if it becomes sort of crystallized on the record where it's clear what everyone is now talking about, this is the specific basis for the venue argument, then at that point, I agree, the defendant could certainly waive that particular basis for the venue argument.
And is that the way you're conceptualizing what happened below, or are you conceptualizing it differently from that?
I think I'm conceptualizing it very slightly differently.
Okay.
My conceptualization is throughout the trial, including pretrial, and the district court ignored the fact that it was slightly after the pretrial motions deadline. The defendant has been making one specific objection to venue. Venue is proper in the Southern District of Florida and not the District of Columbia for the following reasons, which evolved slightly, but were basically consistent. At a later point, mid-trial, I think on November 20th, the district court said, there's a different basis for a venue objection that has occurred to me. What do you think? And at that point, the defendant doubled down on the Southern District of Florida. So I think those are, I understood Your Honor's hypothetical to be more along the lines of a general umbrella venue argument and then a specific venue argument. As I read the record, we have one specific venue argument followed by a different specific venue argument.
Right. I guess I'm more asking if the upshot of the situation is what I had outlined as a hypothetical, because it just seems to me that if in that hypothetical scenario, a waiver can happen, notwithstanding that, as has been pointed out, it has to be right. The burden is on the government. The government actually didn't. I mean, I don't doubt good faith at all, but it turns out that all the information that was before the government should have let the government to understand that DC is not the place that this case should go forward.
Agreed.
Even if all that's true, it can still be waived.
Yes.
Venue can be waived.
I agree with all of that, Your Honor.
Then the question becomes, how do we conceptualize what happened below? Was there an affirmative waiver of the objection to DC? And I take it that the upshot of your submission, even though the particulars of exactly how it came about may vary, the upshot is, yes, there actually was an affirmative waiver of the objection to DC, not on the theory that the burden is on the defendant to show that what the right venue is, but just that it's a waiver of the objection to being in DC once it becomes known that, oh, actually, it turns out the choice on the table either is EDVA or could be EDVA. You can even imagine a defendant saying, actually, if EDVA is even on the table, I withdraw my objection.
Sure. I agree with all of that, Your Honor. I think the waiver, I might characterize it slightly more specifically as waiver of the argument that venue was proper specifically in the Eastern District of Virginia, and for that reason, not proper in the District of Columbia, but that may be splitting hairs. I agree with Your Honor's premise.
I'm not sure that's splitting hairs at all. There's absolutely no, I don't think there's any argument below or any findings by the district court to suggest that he was making an intentional tell you again, I'm going to tell you it thrice, not DC. This is improper. This is legally improper.
Sure. I agree with that, Your Honor, although I might add that I think what his mindset was during trial, and I understand my opposing counsel to agree, is not just we shouldn't be in DC. It is we shouldn't be in DC because we should be in the Southern District of Florida. Mm-hmm. So I believe he was making a specific venue objection. I want to return just very briefly, if I may.
Yeah.
No. That's what we're here for. The other point that I wanted to make about preservation generally is that when this court deals with issue preservation specifically under Rule 12, although, as I mentioned, I haven't found cases where there are two different venue objections and one is made and one is not, this court does deal with this kind of circumstance under Rule 12 where, for example, one suppression argument is made and another is not. And this court has held that merely saying, I don't think there was probable cause for X, Y, and Z, or I make a particular suppression argument isn't enough to preserve the whole umbrella of suppression arguments. So I think although
That's very different. I mean, the government doesn't have an affirmative obligation to come in and show that every single piece of evidence was collected in compliance with every relevant provision of the Constitution, right? That is something that the defendant has the burden to initiate the question, right? And if they don't, they don't. But this is different on venue.
Nooks and crannies, but the basic Rule 12 analysis in terms of how to preserve an argument is the same. This court takes the same approach with sufficiency arguments. You can't just say the evidence was insufficient for a particular reason and preserve the whole umbrella of sufficiency arguments. So I think the logic here is identical. The basis for these two venue arguments are legally different. They're different applications of Section 3238. And
there was actually case law that if you make a general objection, post-government case, maybe again post-trial, insufficiency of evidence, that preserves sub-arguments under that.
Well, I think in the context of making a specific argument, that's not enough to preserve other specific arguments. And I think that's from, for example, United States versus Barrow.
Yeah. I think we're both confronted with a lack of case law situation of what he had to preserve.
I wish we had more, Your Honor, but my general point, I think, is well supported, which is that a specific argument doesn't preserve all other specific arguments. And that's basically how
understand
we.
the specific argument to be, this should be Southern District of Florida, as opposed to the specific argument. He made two specific arguments, not DC, SD, Florida.
I suppose I would see those arguments as a single argument, because as he consistently argued, starting in his pretrial motion to dismiss, his argument about the Southern District of Florida and not the District of Columbia really was one and the same. There is no connection to the District of Columbia. He made the point that the destination of the cocaine importation was not the District of Columbia, it was Miami. So I understand that, as it was repeatedly presented to the district court, to be one unitary argument about venue being proper in Florida and not DC.
Let me ask you a question. My recollection is that when the district court pointed out that the Virginia issue, the defendant didn't really think twice about it. He continued to write in his filings to the court that Zari was first brought to DC. The response from the defendant to the district court's overture regarding Virginia in the filings at that moment was, no, Zari was brought into DC initially.
Yes, yes, that's right. So
There were a number of ways that he was rejecting. The district court was clearly putting it on the table and saying, there's a potential venue issue here. And that was one of the things that he did. He said at one point in his filings, Zari was brought into DC.
Yes, I recall that, Your Honor. And I believe he also proposed a jury instruction that if I'm not mistaken, would have directed the jury that Zari had been brought, quote unquote, to DC. So I agree with Your Honor. I don't think that he made the argument, and indeed seemingly decided not to make the argument, that the district court was presenting to him about the Eastern District of Virginia.
Let me make sure I'm understanding, last thing from me, the thrust of your argument. District court have an obligation as the judge to put, when it becomes clear to the district court what's going on, have an obligation to put the case in the right venue?
Well, I think it depends on the timing. I think because of the operation of Rule 12, if an argument like this could and should have been made prior to trial and wasn't, absent good cause, Rule 12 directs courts not to correct these errors. And I think the district court correctly concluded on these facts that this argument about the Eastern District of Virginia had been waived. Unless the court has any questions about the speedy trial clause or juror inquiry issues, which of course I'm more than happy to address, we ask the court to affirm.
Thank you, counsel.
Thank you.
Mr. Marines, we'll give you 2 minutes for a rebuttal.
Terrific, Judge. Thank you. Again, thank you for your time. I would go back to the burden shifting that's happening, where the government's conceding that they made mistakes, conceding that they didn't provide the proper information to the district court, conceding that Eastern District of Virginia was the right forum, but then continue to rely on Section 3238 as DC being the proper venue. And in doing so, they don't go through the entire steps to determine when a co-defendant offender was first brought. They continue to ignore that factor and rely heavily on the fact that there was some kind of a waiver after the fact. And I would argue there wasn't a waiver. The fact that Mr. Almonte continued to argue against DC is all that is needed. There wasn't a need for him to highlight every venue.
I just referred the opposing counsel to. The response from the defendant was that the co-defendant was brought first to DC. So, I mean, he was doing everything to resist the overture that the proper venue is Virginia. And it is true the government may have the obligation and can be challenged on failure. That's the way these cases set up with respect to lots of matters.
Sure.
But there's a responsibility on the harmed party or offended party to raise the objection and to pursue it. And that's what we're talking about. And if your response is District court's telling you, the government's conceding it. You have every indication now in a timely moment to say it shouldn't be here. So you can say, yeah, the government was erroneous. We want to move it. And you don't take that opportunity. The law also says you lose.
Understood, but I don't think that that was, in fact, what happened, because he doesn't concede DC at any point. There wasn't a knowing waiver and acceptance that the trial will continue in DC. There was always an objection as to the venue. I don't believe it's the responsibility of the defendant to establish that it should then go to the Eastern District of Virginia. The government's burden is to establish the proper venue, and they acknowledge that they did not do that. Once throughout the process, trial counsel continuously objected to the venue argument and continued to argue that the venue was improper in DC. Now, whether or not it could have been in the Southern District of Florida or whether or not it could have been in Eastern District of Virginia is not the burden of the defense to highlight. The fact that they are not knowingly waiving DC and acknowledging that the trial should take place there, even though that the Eastern District of Virginia has become the proper place, and the fallback statute on 3238 does not would concede to the fact that it should have been in Eastern District of Virginia. So I think, having said that, it doesn't go back now to the burden doesn't shift back to the defendant to say what other venues will be proper other than DC. No other questions?
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 24-7127. Gregory T. Angelo et al. Appellants versus District of Columbia et al. Mr. Lyon for the appellants, Mr. Patak for the appellees.
Morning, counsel. Mr. Lyon, please proceed when you're ready.
Good morning, Your Honors. I've asked to reserve 2 minutes for rebuttal. Since Susan B. Anthony's list, no other circuit follows the Navigar-Seegers rule, if they ever did, that standing in a pre-enforcement challenge to a criminal law, other than in the First Amendment context, requires a specific threat or the plaintiffs being uniquely targeted for enforcement. Indeed, 4 circuits have found standing in the exact circumstances of this case, a challenge to a ban on carry or transport on public transportation. And standing is uncontested in a 5th case, Kiptee versus Moore in the 4th Circuit. Conventional expectation that the law will be enforced constitutes substantial risk of enforcement to confer standing. It's time for this circuit to realize that intervening Supreme Court clarification and the overwhelming weight of authority from your sister circuits requires this court to recognize that the Navigar-Seegers line is no longer good law, although, again, I believe that the cases are distinguishable.
So everything you just said sounds like the first paragraph of an en-banc petition that we would take a look at. And I'm just wondering, for panel purposes, what's your best argument that the Navigar-Seegers cases that you rightly started out by referencing isn't binding on us?
Well, one argument is that they're distinguishable, which we've made in the brief. Beyond that, it's not binding because intervening Supreme Court decisions have eviscerated the rationale of Navigar and Seegers. And if you don't believe that, that at the very least undercut it, and the weight of authority from all the other circuits is inconsistent with Navigar and
If
Seegers.
they're distinguishable, why on earth would we talk about whether they should be overruled or talk about what the Supreme Court has said or done? If they're distinguishable, then we don't have to wade into that constitutional question.
Well, exactly, Your Honor. But I can't assume that you'll agree with me on that. So I have to make every argument that I
You shouldn't
have.
underestimate your powers of persuasion.
Good point, Your Honor.
So Navigar, just like other circuits, has been struggling with what the Supreme Court has meant and has continued to repeat. And that is, what is the test for a credible threat of enforcement? And I think the Supreme Court has said, as this court has said, the mere fact that someone wants to do something and there's a statute out there that says you can't isn't enough. Now, your argument, your briefs object to the what more was required in Navigar and Seegers in some subsequent cases. And if you don't want that what more, what is the what more that you propose to make something transform from statute exists out there, prohibits something, I don't like that, I'd like to do it, to a credible threat of enforcement?
Well, Your Honor, I might disagree with you a bit because the Supreme Court has said that that there is a risk unless the government has disclaimed the intent to prosecute or the law has fallen into disuse. I would cite the
Substantial risk under Dry House.
under Susan B. Anthony, it is a substantial risk,
Okay,
but
what
that's
makes something a substantial risk? What makes something a credible threat? Is it just the existence of a statute that says you can't do this?
well, that appeared to be the case in American booksellers, Your
Ask me
Honor.
what your position is. No, I think they'd been visited by some agents in American booksellers. So what is the legal test you're proposing in lieu of the opinions you disagree with? To establish, you can call it substantial risk or of prosecution or credible threat of prosecution, whichever words you want to use.
Well, I guess I would say, again, going back to the Supreme Court, unless the threat is wholly speculative, or the government.
Substituting another word for undefined word for this one. So what makes it not wholly, what shows us that it's not speculative that you will be arrested if you engage in this activity?
Well, one, the district vigorously enforces its gun laws. There's no doubt about that. There have been we documented more than 72 arrests for carrying a firearm in Metro. Police have.
What time period was that?
I think that was over a 5-year period, Your Honor.
How many people rode the Metro in that 5-year time period?
Probably millions, Your Honor.
So 72 out of millions?
But we don't.
That's a substantial risk?
It is.
Odds on it. That's on a lot of things.
Your Honor, there's a substantial risk if my plaintiffs ride the Metro carrying their firearms. For one, there could be inadvertent disclosure of the firearm. If they bend over to pick up something, somebody could bump into
That's something
them.
they can completely control, so.
Possibly, but someone could bump into them, which they can't control. And there are police techniques designed to determine whether someone is carrying a gun. The district uses those techniques to arrest people carrying illegal concealed firearms every day. Moreover,
Not on the Metro if it's only 72 out of millions. I mean, you have to show the enforcement of this law, which is one about use, unless you're talking about on buses and things like that too.
Again, Your Honor, I would suggest that licensed concealed carriers don't violate the law. As my clients have said here, they will not intentionally violate the law, but that doesn't mean that their rights are not being impeded.
I completely understand that point. It's just, I feel like we're getting nowhere on the question of what the right legal test is in your view. You've told us what you think the wrong legal test is in your view, but I don't know what the right one is. It seems to me to be coming down to, there's a law pretty rarely enforced. And we don't like it and we want to engage in that conduct.
Well, Your Honor, in the
Supreme Court
first,
has ever said that that amounts to a credible threat or a substantial risk.
in the First Amendment context, we assume a conventional expectation that the law will be enforced, and that is enough. And there is no basis to make a distinction between the First Amendment and any other amendment. As the court has said in McDonald and in Bruin, and most recently in Whole Woman's Health, we do not treat rights differently. And in here, there is no other way that my clients could contest this law that is prohibiting them from carrying on the metro. What would you want them to do? Get arrested? That's the only way.
Just to be clear, so your position is that the test is there is a statute that outlaws something. My clients wish to engage in that activity, and that is enough to establish a live statute on the books. That is enough to establish, and it's enforced 72 out of multiple millions of times, and that against 72 out of multiple millions of people, and that is. I just want to make sure I'm being fair to what your legal position is. That is a substantial risk, a credible threat of enforcement,
Yes,
or a enforcement challenge.
yes, Your Honor, that's the law of every other circuit.
Mhm.
That is what I get out of Whole Women's Health, where in fact the law at issue indicated it could not be enforced by any state actor, but the Supreme Court nevertheless found that case was judiciable. So as the Second Circuit has said, the test is a very low hurdle. And certainly in this case, where there is no other way that my clients can vindicate their rights, I think that test is wholly appropriate.
Okay. I know you'd reserved 2 minutes for rebuttal, and we'll definitely give you the rebuttal
Thank you.
at that time, but I want to make sure my colleagues don't have additional questions at this time. Okay. Mr. Fatak.
Thank you. May it please the court, Ashwin Pathak, for all the appellees in this case. And I'll just dive right into where my friend left off, which is it does seem like there are two arguments that are being made here. Either Navigar, Seegers, and Parker are distinguishable, or that subsequent Supreme Court decisions have clearly eviscerated those decisions. And I think both of those contentions are wrong, and let me explain each of them. As to the distinguishable point, I think that Navigar, Seegers, and Parker laid out a test, and this is directly responding to your point, Judge Millett, which is that you need to be uniquely targeted or singled out in order to bring a pre-enforcement challenge, a constitutional challenge to a criminal law. Now, that's the test that the court clearly articulated in Parker. It reiterated it in Ord, a case where the court actually found that there had been that kind of unique targeting or singling out, but it found that it didn't exist in Parker. And I have a tough time really seeing the difference between a case like this, where all really the allegations that I'm seeing in the opening brief, page 4 of the opening brief, I think lays out their theory of this case, which is essentially that there's a law in the books. That law in the books is chilling their conduct, and therefore they think they should be able to bring a pre-enforcement suit. I just don't think that's consistent with this court's precedents in that line of cases. And I think this court is bound to apply those precedents. Judge Srinivasan, you mentioned, the appropriate avenue for kind of overturning those prior decisions would be in an en banc proceeding. I think that's correct. And I think that's sort of the avenue to go if the court is concerned about them, but not to kind of overrule them now before the panel stage. And that kind of turns me to the clearly eviscerated side of the argument, which is whether—
Before we get there, can I ask a question? So it does seem to me that there's something that's different about this case. And that is, we're not just left with a there's a law, we want to do it, we can't argument. They also say, because of that law, we have on many occasions and will continue to have to take alternative forms of transportation that cost us more money. They allege a pocketbook injury that happened and is going to continue to happen. It's exactly what the law is intended to accomplish. Don't bring those here. Don't come here with those. Get yourself around some other way. So this law says that to them. And it has happened, and it is, they say, will continue to happen. Now, in Virginia versus American Booksellers, it was a preliminary injunction case. And what the Supreme Court found relevant there was that they had incurred and were going to incur substantial compliance costs. And that was their injury. Why is that not sufficient here?
Well, so a few responses to that. I think that theory is inconsistent with Navigar. So in Navigar, there clearly was a financial cost to those gun manufacturers.
I get it was briefed. Our opinion does not analyze that issue at all. So now I'm raising it in this case to say, well, what if we analyze that?
And I think another point here, I would just note at the offset.
Our cases have addressed and said a pocketbook injury that has happened and will continue into the future, just like the expense. It was expense of going through all their inventory in American Booksellers that was the injury. What case of ours has rejected that as a basis for standing under Navigar and Seegers?
I agree. I don't think any of that line of cases directly addresses that argument, but I think it's implicit in Navigar. And I think that really
it's implicit in Navigar.
Well, I think
it just doesn't talk about it.
Well, I think I guess the way that I read Navigar is that you have ATF agents coming to gun manufacturers and basically saying there's a new law in the books that prohibits certain manufacturing that you do.
Argue for standing on that basis, or they didn't. The court's opinion did not address an argument for standing on that basis in Navigar, or in Seegers that I saw, or in Parker, and that wasn't the basis in Ord. And so I'm just asking, why would this even be a case for on bank? Because it seems to me there is standing because they have incurred the very financial costs that the law was designed to force them to incur. And that's an ongoing injury. I'm not saying they get damages, but it was sufficient for injunctive relief in American Booksellers. I don't know why it wouldn't, standing for injunctive relief, I don't know why it wouldn't be here. And so, you have a way of distinguishing that?
Well, I have a way of distinguishing American Booksellers, which is that it was a First Amendment case. And I'm happy to talk about the distinctions that I see between those two. But I do want to just directly take on the particular point that you're making, which is, and I think Judge Moss addressed this in his opinion, which is that basically you can't have an economic injury that is fully premised on actions you are taking based on this very same speculative harm that you're making in the first instance. So the speculative harm that you're suggesting is that there's a law in the books that's...
I think the whole purpose of this law is to say, if you want to travel with guns, do it on another form of transportation. Isn't that the whole point of this? Don't bring them here. If you've got guns and want to travel, do it on another form of transportation.
Right. But I guess taking that other form of transportation is premised on you believing that there's a threat of prosecution. And if it's the same threat that you're asserting is based on the same chill that you're asserting based on the law that's in the books that you think is unconstitutional, I guess I just don't see the difference there. It's the same threat, right? It's the same threat that...
Nothing speculative. The law, this isn't a vague law. The terms are crystal clear. The fact that their conduct would fall within it is crystal clear. And the purpose of it is crystal clear. There's no daisy chain of inferences at all. This is a criminal prohibition meant to change behavior. And they have changed their behavior in response to it in a way that's harmful to them. It's out-of-pocket expenses. And I just don't understand why you could say, well, it seems strange to me to have the district responding with the argument that, no, that's your fault for spending that money. Please ride the Metro with your guns.
Well, I mean,
they've got two options, ride the Metro with the guns or spend money. And your answer is, what are you worried about riding the Metro?
I guess I don't see this as being that different than, I guess, the argument that the Supreme Court addressed in Clapper, right? I mean, that was a case where they asserted that they were changing their behavior in response
I know,
to a
but they were
threat.
doing there, this report already found that it was sort of a speculative daisy chain of things. You had to assume this person was going to get tapped, and then this person would do, and then you would be here, and then this thing would here. There's nothing like that here. There's no chain.
I guess there is,
We're on.
I guess.
Law is accomplishing what it's meant to accomplish.
I certainly understand the point, Judge Millett, and I'm not, and I agree there, that is a distinction. And I don't want to kind of keep harping the point. I do think that there is a similarity in the argument that a person is taking action in response to what we see as, under this court's precedents, a speculative threat of prosecution, that you can't sort of manufacture standing based on that same threat that otherwise wouldn't be sufficient to bring you into court and give you Article 3 standing. And I do think that is a distinction.
I guess this is a criminal law meant to change behavior, correct?
That's correct.
Is
And
it meant to keep people with their guns off metro system transportation?
it certainly is. And I don't,
Exactly the purpose of it.
that's right. But I just
That
don't
costs
see that.
people
I
money.
don't see that as being much different from Parker, Seegers, and Navigar. I mean, those were criminal laws intended to change
Talk about
behavior.
pocketbook injuries. I mean, pocketbook injury is usually, your ticket directly through Article 3. As long as it's not self-inflicted, and this is not self-inflicted, it's inflicted by the statute. It's the whole purpose of the statute.
I agree with that. And I see that as being, written through Navigar, even if the court didn't specifically say it, that is like the premise of what the gun
You
manufacturers
don't
were
have
saying.
precedent
But
rejecting pocketbook injury is sufficient in a case where statute's crystal clear. This isn't someone where it's like, I'm not sure if things are covered or not, which is just a whole different either standing or ripeness issue. Crystal clear, straightforward. The fact that their behavior falls under it, again, no ambiguity whatsoever, nothing speculative about that, square on. And so the government has chosen to regulate us in this way, and we're incurring these expenses.
I mean, I guess I agree with everything that you're saying, and I don't see how that makes this case distinguishable from Parker and Seegers and
We're not a
Navigar.
criminal law, but instead we're a regulatory decision. And they fell within the class of regulated parties. And they wanted to bring a pre-enforcement challenge to agency regulation that has cost and is going to cost them much more money. Would they have standing under our precedent for
It seems like,
agency cases, agency regulatory cases?
yes, it seems like the answer is yes.
How
And
can Article 3 answer those two questions differently?
I agree that is a strange feature of this court's precedent. I'm not going to deny that. I mean, I do think there's,
Enforcement too, so, yeah.
right. I mean, I do think there's actual government action, and there is clearly an Article 3 bar when it comes to agency challenges as well. So I don't want to suggest that there's, nothing there. You clearly have to show
But
that
they
it's
don't have to
directly
wait
impacting
until
you.
agency officials are, ordering them to turn over documents.
Correct.
Things like that.
Yes,
One
that
of
is
the ways
true.
you really get into court is this regulation is costing us money and it's going to keep costing us money. Let me talk to you about that. And we go, okay. And there's nothing, they're not misreading the statute or anything.
No, I agree with that entirely, Judge Millett. And I think that I don't have a great answer for how
Article
those.
3 in both situations.
It is the same Article 3. That's exactly right. But I do think that Parker and Seegers specifically spoke to administrative cases and said that is a different, a carve out essentially. And it also said that First Amendment is a carve out, which, does, I think, answer in part the Virginia v. American Booksellers case. And that is throughout this court's case law, whether it's the Woodhull decision from
Usually when the First
2020.
Amendment's carve out, it's because it's chilling.
Right.
Speech. Yeah, no, it's going to cost us a lot of money to go through our inventory and figure out what we can display and not display. It's going to cost us an extraordinary amount of money. That's what they were talking about. I mean, they said the requirements met here as the law is aimed directly at plaintiffs, this case too, who, if their interpretation of the statute is correct, will have to take significant and costly compliance measures or risk criminal prosecution. Does that completely describe this case?
In many ways, other than the First Amendment implications of that case, I
Okay, well,
think. But I agree entirely.
Citing Craig versus Boren, I don't even remember if that's a First Amendment case.
I mean, I guess there does seem to be a First Amendment, some distinctions in the First Amendment, right? Those overbreath claims are allowed in the First Amendment. They're not allowed with other constitutional rights. We're worried about prior restraints. Correct. And I agree with that. Right. But I think most of the First Amendment cases were really about overbreath, and they were challenges where you really were worried about chill. Whereas as a general matter, even the Supreme Court in the whole woman's health decision, 5 votes for the proposition that, and I'll quote, the chilling effect associated with a potentially unconstitutional law being on the books is insufficient to justify federal intervention in a pre-enforcement suit. But, I understand the distinction that you're making, Judge Millett. I agree with you that the court did not directly address that argument in those prior cases. I see it as being implied, at least in Navigar, but I don't want to, push back too hard on that point.
What do we do with the language in Bruin that says that Second Amendment rights are not second-class rights? Because if you draw a distinction between the First Amendment and other rights, I get that the cases have a kernel of that in them, and one could follow that in a certain way. But then there's language that says the one thing we don't do with the Second Amendment is treat that as differently. Second class right.
That's right. That language is there, Judge Srinivasan. I'd have a few responses to it. The first is that in the whole woman's health decision, I think the court actually sort of implies that actually maybe it was wrong about the First Amendment. In other words, that everything needs to be leveled up. That's how I read that passage from whole woman's health. So that may be where they're headed with this, and maybe some of the prior decisions that they've issued as to the First Amendment, they're going to think about revisiting, and that maybe they think that everything should be held to kind of a higher pre-enforcement standard. But I guess the other thing that I would say is that since both Bruin and Whole Woman's Health have come out, many other circuits have reasserted that there is this special First Amendment rule as to standing. And I think it's not necessarily inconsistent with the notion that the Second Amendment is not, a second class right, that you might just have a special standing pre-enforcement rule for First Amendment challenges in particular, given the nature of the injury that we think about in those cases. It's chill, it's about prior restraints. I mean, you can have a prior restraint in the Second Amendment context, right? That's licensing and registration. The Supreme Court has made clear that, for the most part, those types of regimes are okay. You certainly can't have a license, requirement to go out on the street and say what you want to say, put aside, parades and things like that. But as a general matter, I do think the First Amendment is thought of as just a little bit different in that regard. And of course, as I mentioned, you can bring an overbreath challenge in the First Amendment context. So I completely understand that language from Bruin. I just don't think that the court has fully fleshed out how that should impact pre-enforcement constitutional challenges, and whether it really is true that the First Amendment and all of the other constitutional rights are exactly the same, because I think that would be quite a sea change in the case law. So I just worry about sort of assuming that they've completely altered that without something a little bit more concrete.
And then can I ask you, in response to some of the colloquy that you have with Judge Millett, so is your understanding of Navigar and Cesar that the common assumption from those decisions is that conduct that would have been engaged in will not be engaged in because of the fear that it violates the law, but still there can't be a challenge?
Yes, that is how I read. Yes, that's correct. That's how I read Seekers, Parker, and
no, it's not that you're supposed to actually go ahead and engage in the conduct because the risk of prosecution is low. It's that where everybody's assuming that you're actually not going to engage in the conduct that you would like to engage in, but you're not going to engage in it. But still, you haven't shown the degree of injury that's required to be able to vindicate your right to engage in that conduct.
Correct. I think that is what those cases are saying, and that they're saying you do need to be uniquely targeted or singled out in order to challenge the law. And that requires something more than just pure chill based on a law you believe to be unconstitutional being on the books. And, even the Supreme Court has sort of reflected that principle, but hasn't obviously addressed it specifically. But this court, I think, has clearly addressed that in those decisions. And they've done it in the context of a few different laws. I mean, the trigger lock law in both Seekers and Parker, I think, is very similar to the situation here. There was no administrative remedy in that situation, and nonetheless, the court said that you couldn't bring a pre-enforcement challenge to it, even though it clearly was affecting their conduct.
If that's the assumption that we operate under, then if the plaintiffs invoke something like a pocketbook injury, is the way you're conceptualizing that look, there's all kinds of particularized injuries that could follow from the fact that you're not going to engage in the conduct that you'd like to engage in. But any of those kinds of particularized things you could point to are all derivative of the fact that you're not going to engage in the conduct to begin with. And once we know that that's not enough to give you standing, which we know from Navigar and Seeger, then it doesn't matter what the particular things may be that follow from that. We could have we could talk about pocketbook injuries, which definitely have been recognized in the cases as significant, as sufficient. And but the lesson you're drawing from those decisions is that's just one specific example of a derivative injury that follows from the primary conduct that you're not going to engage in, which is you're not going to engage in the conduct that the law brings within its compass.
That's correct, Judge Srinivasan. And I think the point I was trying to make was that if the pocketbook injury is premised on the same chill that you are asserting in terms of seeking declaratory and injunctive relief, you can't sort of manufacture injury just by acting in a way that responds to that same chill. So it's sort of a redux of the same argument is how I read the case law. I don't want to suggest, obviously, that, that this court articulated the point that I just made and you just made in its decisions, but I do read that as...
It wasn't made. I mean, there was no discussion of that.
Right. But I do think that sort of flows from other, that's certainly how I'm theorizing it. And I see that in other decisions. I mean, I do see that in Clapper, and I understand, Judge Millett, that there is a, long series of, a speculative chain in that case. But I take the court as saying that as addressing the speculative chain argument first, and then saying, oh, by the way, you also can't manufacture injury by suggesting that there's some, pocketbook harm that comes from that same speculative chain. So I think I'm trying to make a similar point here, which is that you can't kind of have a redux of the same argument via economic harm.
Make sure there's no additional questions. Okay, thank you, counsel. Mr. Lyon, we'll give you the 2 minutes that you asked for.
Thank you, sir. With respect to the last point that counsel made regarding a speculative chill, this court has already addressed the question of what type of chill is sufficient to confer standing. And I would contrast Clapper and similar cases such as Laird v. Tatum with cases where this court has said if the statute is regulatory, prohibited, or compulsory. And this certainly falls within that area. Counsel suggested that Whole Women's Health suggests a higher bar for standing. I think that is simply not possible to discern from that case. Going back to the question of what is the standard, I would quote from Babbitt that a credible threat of prosecution exists when fear of criminal prosecution under an allegedly unconstitutional statute is not imaginary or wholly speculative. And I certainly don't think that my client's concern with arrest is imaginary or wholly speculative here. We certainly do agree with Judge Millett's point that we've incurred financial costs to comply with this statute, and that would constitute injury for standing as well. And lastly, we seriously question whether there is or should be a carve-out for First Amendment cases. The Supreme Court has made clear that the exception for standing in First Amendment cases is only for overbreadth cases, and that is, quote, strong medicine. And there has never been a rationale either by the Supreme Court or this court to suggest that on other areas of standing that there should be a First Amendment exception. And I think that Bruin and McDonald and Whole Women's Health would certainly argue against such a point.
Thank you, counsel.
Thank you, Your Honors.
Thank you to both counsel. We'll take this case under submission.
Case number 25-51, Centro de Trabajadores Unidos et al. Defendant. Mr. Scott Bessent in his capacity as Secretary of the Treasury et al. Mr. Joshi for the appellants, Mr. Henricks for the appellees.
Morning, counsel. Mr. Joshi, please proceed when you're ready.
Good morning. May it please the court. I'm Nandan Joshi for the appellants. Congress enacted Section 6103I of the Internal Revenue Code to limit law enforcement access to confidential taxpayer records. That provision generally requires prosecutors to obtain a court order to access information in a particular taxpayer's IRS filings. Here, however, the district court held that 6103I2 allowed the IRS to disclose millions of taxpayer addresses to ICE without a court order. That was error. I2 is not designed to give law enforcement easy access to taxpayer addresses without a court order. It assumes that law enforcement already has the taxpayer's address and will provide it to the IRS to obtain access to third-party sources of information. So the way 6103I works is that there are a set of documents within the IRS that are independent of information the taxpayer submits to the IRS, for example, in their 1040 or in their W-7 application for an ITIN number. These might arise from an IRS investigation into a third party where they obtain information. They might arise from a police raid, for example. That's one of the examples the IRS gives in its manual, where the information comes from a third party, not voluntarily from the taxpayer.
Does it include, I'm sorry, I just have some questions about how this works. Does it include when your bank sends in information about your interests?
If the
or
bank
when, your employer reports your income?
So if your bank or your employer sends in information about you, that would be protected information. That'd be taxpayer return information.
Even though it's submitted by a third
Yes,
party?
it's by or on behalf of the taxpayer.
But if they, in doing so, the employer shows its address or the bank shows its address, that's not protected information.
I'm sorry.
So presumably in sending this in, the bank is going to reveal its own address or the employer will reveal its own address. That's not protected.
Yes, I don't believe that is not protected as to the individual taxpayer. It might be protected as to the bank.
Yeah.
However, for example, if the information comes to the IRS involuntarily of the taxpayer, if it's seized in a police raid the police raid a business on a RICO case, somehow the business records end up at the IRS. Some other law enforcement agency can, if it knows of that, can use I2 to get access to those records if it follows the procedures set out in I2. Those are not
all of those records, including, say, they have copies of the W-2s for.
Yeah, that's the IRS's position. I don't know that it's been litigated, but that's the IRS's position. 6103 distinguishes between taxpayer return information and other types of return information.
It was crystal clear distinction to me.
Yeah, well, the underlying purpose when it was enacted in 76 was to encourage people, taxpayers, to voluntarily participate in the tax system. There is, of course, penalties for not participating in the tax system, but Congress said, in the wake of the Nixon scandal, said that's not sufficient. We want to preserve the integrity of the tax system by saying, when we force you, taxpayer, to submit this information, we're going to protect it as if that information were in your own home. And we're going to require a court order if law enforcement wants to get that information. And they have various provisions for that. A1 is the primary one for criminal investigations. I1. I5 was enacted in 82. That says prosecutors have to get a court order to get the location of a fugitive from justice. And the IRS took the same position for a long time, saying law enforcement cannot use I2 to get these types of addresses. Law enforcement must provide us the name and address of the taxpayer in order to get this third-party information if it exists for a particular taxpayer. The type of information you're talking about, many taxpayers may not even have the third-party information because they're not going to be investigated by the IRS or have independent sources of information. So what the IRS did here in response to the new administration's immigration agenda is say, we're going to rethink what I-2 means. And now.
And they're basing their rethinking on I2C because I2C
Yes.
does have a carve out for taxpayers.
It does. It does.
So, I mean, nobody disputes that if information is sought outside of taxpayer identity and taxpayer identity is disclosed as it can be, as it must be actually
Correct.
under I2C, then that taxpayer identity information can be used in the way that it's sought to be used here, as long as the request actually was accompanied by a request seeking other information.
I think that's basically right. The one caveat I would say is Congress's premise in allowing that type of disclosure, because initially it didn't allow that disclosure. In 76, it did not allow that disclosure. And
And then in 78.
there was a technical fix in 78 because the theory is law enforcement already has this information. It doesn't make any sense for the IRS to then not be able to provide it back simply because it came from taxpayer returns as opposed to some other source. And so we're going to have this technical fix where we're going to treat it as the type of information that can be disclosed without a court order in response to a valid request.
So can I just stop you there? So that's what what's the reason for the carve out in C for taxpayer identity? I mean, the way you just articulated it, as I understood it, was that, look, if somebody's asking for the information, they have it anyway. So why not just let it be turned over? But why? If they have the information anyway, then why turn it over? It doesn't tell me what's the affirmative interest in the carve out for taxpayer identity, and what is it?
Yeah, I think from the 78 legislative history, it was at least ambiguous. I mean, what you said made a lot of sense. Perhaps if they didn't enact that exception, the law would have been allowed the IRS to turn that information back over to the law enforcement agency that requested it. And what, Congress was concerned about taxpayer addresses, just like any other piece of information that a taxpayer might file in their tax return. And so they just wanted to clarify that this is, in this sort of situation, it's not, it doesn't raise the same privacy concerns and the same threats to.
Why? I'm still not completely understanding. Why have the carve out for taxpayer identity so that taxpayer identity not only can, but must be turned over? If I'm understanding this correctly, right? Because under I2C, when there's a request from an agency, the general bar against turning over, I forget the term, taxpayer return information,
Right.
It doesn't apply to taxpayer identity.
Correct. The current formulation does not apply to taxpayer identity.
And why was it done that way? Why is there the carve out for taxpayer identity to allow taxpayer identity?
Yeah, I think Congress might have been, they wanted to clarify the law. They also might have been less concerned about the privacy implications of the IRS confirming that the name and address that the law enforcement agency provided was in fact the name and address that was reflected in the tax returns that identified the taxpayer for purposes of this other type of information that was a legitimate purpose for under I-2, the third-party information that law enforcement could seek. So I would say it's just a technical fix to sort of streamline.
But a fix to what? I mean, I think you're assuming that I know more than I do. I think I'm not understanding what's it fixing. Why the affirmative? There must have been an affirmative interest on the part of Congress in assuring that the taxpayer identity information can be transferred from the IRS to taxpayer identity, if I said that right, can be transferred from the IRS to the requesting agency.
Sure.
Why?
Well, in the 76 law, that wasn't clear. Right. Taxpayer identity would have been taxpayer return information. It wasn't clear that the IRS could hand that back.
Exactly. So why did it need to be clear that it can be?
Well, I mean, when the IRS violates or an IRS employee violates a provision of of these protections, they're subject to criminal liability.
No, I get that, but why should they not be subject to criminal liability? I'm trying to understand what's the policy interest in making sure that taxpayer identity information can be turned over. Somebody must have thought there's a reason we need to make sure the taxpayer identity information can be turned over. What's the reason?
Well, once again, I think it was simply to ensure the IRS, when they do send that back, that information back, that it's not going to lead to any concerns about liability on the individuals who are the employees who are doing that.
But why wouldn't we want them to be liable?
Because there was, well, once again, if the law enforcement agency already has that information, there's less of a privacy concern of turning that back over.
But they might have wrong information.
Well, they have.
So suppose that so they have an old address. The law enforcement has an old address, and they say, this is the name of the person. Here's the best address I have. And then it could be that the response would be, okay, well, that's the address you have. The IRS isn't supposed to correct that. They're not supposed to turn over the correct address. And yeah, you requested it with the wrong address or an old address, but there's no reason for a carve out for taxpayer identity if the policy determination was made that, look, that's okay. They've got the wrong address. Fine, they've got the wrong address. We're going to turn over all the other information that they've asked for. But the one thing we're not going to do is correct the address.
No, well, they shouldn't turn over all the information. If they can't match up the name and address, that's not a valid request.
No. Suppose I disagree with you on that. I mean, I just assume for present purposes that I don't think there's a burden on the IRS to make sure that the address that's in the request is actually the correct address. That may be an argument that's out there. It's unclear to me how forcefully that argument is being presented, but let's just suppose, and you might resist the assumption, but let's just suppose that I don't agree with you on that I think, just for purposes of this question, let's suppose that there's a name and an address. It turns out to be an older address, but that's not enough to turn off the entire spigot, that you still have to turn over. And I'm not talking about a case in which only address information is being requested. I'm talking about a case in which the other things that everybody agree can be requested is being requested. That just because the address is an old one in the request, it doesn't mean that the IRS doesn't have to turn over everything. They turn over the other information that's being requested that you agree can be requested and needs to be turned over. Why was it the decision made that in the course of turning over that other information, the IRS also turns over the address?
So I don't know that a deliberate decision was made in that context.
But it definitely was, because that's the whole point of I2C, is that to make sure the taxpayers, as you rightly say, there was a question about whether taxpayer identity information could be turned over, and there was an affirmative decision made to make sure that it can be.
Right. And once again, I think the concern that was before Congress's mind was that under the original 76 law, nothing could be turned back over that was taxpayer identity related. It was a technical fix to the law. It wasn't intended to create this loophole where a law enforcement agency could submit.
What was the problem that it was technically fixing?
Right.
All we have is the legislative history of the 78 report, and it mentions this problem that there was this, they were concerned that the IRS could not identify the material it was turning over with respect to the taxpayer's name and address.
So that the act of turning over things that can turn over would necessarily confirm the accuracy of the address. Is that makes sense, I guess.
Yes.
As we respond, then we're going, okay, yeah, we do have somebody on this.
I mean, and I don't want to
address.
I mean, I think the whole point is that this was a technical fix to sort of clean up the operation of the statute. It wasn't to create this loophole that allows law enforcement to, send over a spreadsheet of 1.3 million addresses and ask for updated addresses for all these taxpayers without any request to go after the types of information, third-party information that I2 is designed to facilitate without having to go to court and get a court order. And so I take your point, Your Honors, that it doesn't seem like much, but that's the whole point. It was a technical fix to the statute in 78, and in 82, when Congress wanted to allow prosecutors to look for the location of a fugitive, it enacted I-5. It didn't try to shoehorn that into I-2 and say you can do that, get that information without going to a court and meeting with strict standards.
Let me see if I can, I have to ask it my way. The statute literally does not support your position. I-2 says it can get disclosure of return information for use in criminal investigations. And we know from C that mailing address is part of the information that would be included in that term. That's just clear. There's nothing you can say to refute. If that's all we're looking at, that is absolutely clear.
That's,
right?
Your Honor, that's exactly our point. That's what the district court held. And what the district court.
Wait. So that's straightforward. Now, I'm trying to understand, one argument you're making is, well, it's kind of, as best I can understand, it's a little strange that in order to get that information, which the statute says they can, they have to give an address. Do you think that's really dispositive? Because as my colleague has said, it doesn't say what address they have to give. The government simply has to present whatever they, wait, let me finish, okay? So we're back down to the statute says, because of C, the mailing address is clearly return information, and I-2 clearly says the government can get return information for use in criminal investigations. What else is there apart from what you think is strange that you have to give an address to get an address? I hear your argument, and maybe it is strange. Is there anything else? The legislative history, I must say, I waded through it. First of all, we're skeptical of that kind of evidence, and I don't think it's powerful here. What else is it that gives your argument real weight other than this strange address in B, an address in C? And that seems strange to you that you would require someone to give an address when they're seeking an address? Anything else?
Well, a few points, Your Honor. First of all, I don't, in B, when it talks about the name and address, if you ask me what my name and address is, and I gave you my name and I gave you my childhood address, you would not think I was very honest. So it's not just any address. It has to be something that is the address of the taxpayer. That's so I think it's a little bit more than straight. It's incongruous. I agree that if you just look,
you got to have more of an argument than that. Okay, I hear you. Go ahead.
No, I understand.
They shouldn't overtly lie. You're saying, okay, let's accept that. But still, they can come in with the wrong address and be mistaken. And the statute doesn't appear to prohibit that. They could have a 2015 address. That's the best we have. And we have to give you an address. Here it is. It turns out it's 2015. It turns out IRS has the current information, and that's what they want. Now, how is that forbidden? Why? I'm not getting it.
So, well, we talked about B. There are a few other structural issues with.
No, they've got to follow the rest of the requirements under B. Okay.
Yeah.
But go ahead. What else?
So we have I-4, which talks about submitting taxpayer return information in court proceedings. And it does not carve out the taxpayer's address. I think for the reason is that Congress anticipated the law enforcement agency would already have the taxpayer.
Do you think there is a positive requirement of court support for this request? Is that one of your arguments, that you have to have a court order getting to be able to get this under the statute? Because again, I don't see that. Where do you think you're getting that? There are other provisions that do say that with respect to other matters. I don't see it with respect to return information and this particular provision. Where do you see it?
Well, definitely, certainly A1 and A5 talk about getting a court order to get taxpayer information. They are broader than I-2,
right?
Admittedly, but that is the general premise of 6103I that sort of distinguishes between the protections.
It's surprising that wouldn't be in B if that was a requirement. Court order. Seems to me requirements and then they list the things that the statute assumes you've got to come with. And if court order was one of the things, I would expect it would be there if that's what Congress meant to say.
Right, and the reasons 6103I2 does not have the court order requirement is that the expectation is that the information being requested is this third-party sourced information, not taxpayer address information or the alternative would be every filing a taxpayer makes throughout their life that to the IRS, every tax filing, all their addresses are free game for law enforcement. So if the law enforcement
Used
says
in a criminal investigation, we're only talking about.
yes,
So it's not, everything is open in a situation where it's certifiably for use in a criminal investigation. That's the exception we're talking about.
right. All 6103I is about,
So that's
most
not
of it's about
everything.
criminal investigation.
That's not everything. That doesn't mean in every situation when someone comes in.
No, yes, no, it means though every address the taxpayer has ever filed with the IRS becomes free game without a court order for criminal law enforcement to ask the IRS, give us this taxpayer's address history.
Okay.
And
If they have a criminal investigation purpose for seeking.
yes, if they have a criminal investigation purpose for seeking it, which isn't, I mean, all they have to do is, identify the statute and provide specific reasons for the information. If they're looking for current address, as ICE is doing here, that's easy to meet. They just say, we want to find it's always relevant to try to find the
By way,
individual.
on that score, I understand that a lot of the underbrush here is about finding the individual. I actually didn't understand that that's the rationale that's being put forward in the MOU for getting the latest address, because I thought the rationale that's being put forward is not that we want to be able to find them so that we can do various things, including, as you suppose, potentially have civil removal proceedings. But it was that knowing the current address would let you know whether and then comparing that to the date of the removal order would let you know whether it's beyond 90 days.
Right.
Sure.
So that's the element of the offense. It's not actually finding the person in order to be able to implement criminal process. It's to prove a violation of the statute.
So a couple of points, Your Honor. First of all, the MOU, the very first paragraph talks about the desire to identify, exclude, and remove aliens.
I understand that. I mean, I'm not going to suggest that that's, completely out of the picture. I get it's sort of like saying that everything that's being done is informed by a priority of an administration, which I don't deny that point. But I'm just saying that as I understand it, and as the district court opinion says this, and I think some of the briefing says this, the primary stated reason for seeking address information here, it relates to an element of the offense, which is to show that it's beyond 90 days past the removal order date. And one thing that's interesting about the MOU is that it requires, as I understand it, there has to be a removal order and you have to disclose the particularities about that.
This MOU is limited to the removal orders in that sense. However, the MOU talks about other federal criminal laws, just like the statute does. And the IRS and the defendants here have taken the position that the MOU is sort of window dressing. If ICE came back tomorrow outside the MOU, they would still have to comply with the request for address information for other types of crimes. And I will say the statute, when it talks about the relevance of information, doesn't talk about element of the offense. So once again,
it doesn't. I take that point, but as I understand the theory that's being put forward here, that's the theory, is that the current address information bears on whether the person has overstayed 90 days beyond the date of the removal order.
I mean, that is what they've put forward. I think it seems perplexing that they could do that on a bulk basis, say that it's relevant in each case, depending on the information they get back. We don't have information about how ICE is actually
Seems relevant. I mean, doesn't it? Isn't it?
Well, they would only get back the date, the address, and potentially the fiscal, the tax year.
For a tax year, right? So
Yes.
if the removal order was 10 years ago and it's the current tax year,
They should not get back where that information comes from. So it doesn't necessarily have to come from a 1040. I don't know if.
well, wherever the information comes from, if the idea is, suppose you have a situation in which the removal order was 10 years ago, and then the latest address, where it comes from, a return or wherever it comes from, is FY 2025 or tax year 2020. I'm speaking of fiscal years, not tax year. So 2025. Then that would tell you something about whether the person's overstayed by beyond 90 days.
It's possible. We once again, they could say we want this to locate the individual, and that would also be possible. So I mean, that's not really a limitation in this context. And ICE wears two hats, and they have a criminal hat and a civil hat, and they can achieve civil purposes wearing their criminal hat, which I think even the district court recognized, but thought that was legitimate. I mean, they are allowed to use this information to contact a target and essentially propose a plea bargain that says if you self-deport or turn yourself over to civil authorities, we won't prosecute.
Right.
That's wearing their criminal hat.
Which is kind of a natural part of the criminal process that often
Correct.
occurs.
Whether that, is or independently is or is not a permissible use of this information, the whole scheme depends on ICE being able to make a bulk request for taxpayer updated taxpayer addresses instead of the sort of one-off request that I2 was historically used for by prosecutors to get this sort of third-party source information. It would go,
just so I understand your argument. So on the standard one-off request, what you've used standard request, and I think it has been historically the standard request, you don't dispute that if there's a standard request that involves someone who would be within the compass of 8 USC 1253A for overstaying beyond 90 days, you don't dispute that if there's a standard request that encompasses other return information, the kind of standard types of stuff that you see, and then the current mailing address would have to be turned over, and the current mailing address could be used in exactly the same way that it's being sought and would be used in this situation, understanding that here, that's the only thing that's being sought and it's being done in bulk.
Well, I guess I will go back to your earlier premise. I would read the address that has to be turned back over to be the same that was applied. I know Your Honor said that was the same that was used to apply, but that.
Okay, go ahead and finish that because I have a question about that premise, and then we'll move on.
Yes, but otherwise, I would agree with Your Honor that the answer to the question is yes.
Okay, then on the premise, so if I'm understanding right, if your argument is right, that the address has to actually be the current mailing address, the address put forward in the request has to be the current mailing address. That's your position, right?
Yes.
If that's true, then if you have a situation in which it's a standard one-off request and it's for other return information that's directly relevant to a criminal prosecution, and the requester happens to not have the current mailing address, is your view that what Congress intended was that because the requester, who has even in your view, an entirely legitimate law enforcement interest in seeking that information to prove, let's say, an element of the offense that's proven by not the return information, not the address information, but return information that they're seeking, that the IRS is duty bound to say, no, we can't give you that return information because you haven't given us the right mailing address?
The IRS has to, one caveat to that position, the I-2 allows for information on prior tax years. So it could be a plausible reading of the statute that if they're providing the address for a plausible tax year, a past tax year, they can provide a prior address. I think the better reading of the statute, though, is that not any old address would work. But even if the court rejects that and says an old address would work for a legitimate request for third-party information or I-2, in which case the IRS has to then provide the new current mailing address, that still doesn't justify this situation where they're seeking this addresses only on a bulk basis without getting the sort of going through the court process that I-1 and I-5 would require for location information.
If they set up a computer, it would send in a request every minute because they're just going to be changing the name and address. So that in fact, they were submitting 3,000 requests a day, but individually. Would that be okay?
No, once again, I don't think the proper,
Individual requests.
well, I think they have set up a system. That's how they process the 1.3 million. I don't think that the issue turns on whether they do it in a single spreadsheet or a computerized one-off request for information.
So it doesn't matter. The volume really doesn't matter.
The volume doesn't, I mean, no, not legally, it doesn't matter if they did this for one or for several million. But when you allow them to, if you allow them to simply seek addresses, then that makes them able to seek it on a bulk basis or on a seriatim basis. When you limit I2 to third-party sources of information, it necessarily requires them, when they're filling out the request, to identify, why that particular piece of information is relevant to a criminal investigation. As a practical matter, that I think that forecloses the sort of bulk processing scheme that they have here.
Okay, I understand your point.
I'm over my time.
Thank you, Counsel. We'll give you a little time for rebuttal. Mr. Henricks.
Thank you, Your Honors. Aaron Henricks for the appellees, and may it please the court. Plaintiffs here seek relief that would prevent the IRS from sharing information with DHS despite a statute that mandates such disclosure and despite both agencies' compliance with that statute. As a threshold matter, plaintiffs lack standing to maintain this suit. And regardless, the district court acted well within its discretion in denying the the motion for preliminary injunction.
You started by saying the statute mandates it. Is it right that since the statute was enacted in 1978, this has never happened?
I believe it's correct that this particular request from this agency.
No, not from this agency, just a request for addresses alone has never been successful.
I'm not sure if a request for addresses alone has ever been attempted, but
We came up with the selective service. I thought that was a lot of the underbrush it was about the selective service. So everybody knew that this was a possibility.
Right. As to the selective service example, no request was actually made through 6103 I2 to find information on people who had failed to
It could be no
register.
request was made because nobody thought it was possible. I guess all I'm trying to nail down is that whether you're right or wrong about what you see to be a statutory mandate, this dynamic has never played out before in the how many ever decades has passed from the time that this IPC was enacted.
Yeah, the IRS has never been forced to wrestle with whether this is mandated or not. The statute seems to imply that it's mandatory. And as to the selective service example, it wasn't that they didn't go forward because they thought it wasn't mandatory. And in fact, the memoranda on the selective service issue never made a clear conclusion. It said it's a difficult question, but never made a clear conclusion, and probably due to policy reasons, never actually sent over an official request to the IRS. So I'll begin with standing if there aren't other questions in the immediate. Yep.
I have some questions about how this works.
Okay.
Is it okay? So the argument here is that the MOU is just a reduplicating the statutory requirements. One of the things the MOU says in both section 5 and 6 is that ICE will make these requests for information.
Correct.
Is ICE one of the statutorily authorized entities to make a request for information? I don't see them on the list in 2A.
It's a head of an agency, and as to these examples, the head of ICE, Todd Lyons, signed.
Is ICE an agency? I thought DHS was the agency. ICE is a component of an agency.
I believe pursuant to 6103, the head of an agency that ICE qualifies. Excuse me?
Is that missed somewhere? Is there a definition somewhere? I would have thought the head of the agency would be The agency here is DHS.
Correct. My understanding is that
I mean, it's
the head of ICE.
pretty carefully enumerated list. And doesn't include anybody involved in immigration enforcement other than if it was the criminal immigration enforcement, the deputy attorney general, or the FBI. And if the requests were coming from the Department of Homeland Security or the head of the department, the secretary, that would make sense. But you defining ICE as its own independent agency?
For purposes of getting information,
That's not the list. I mean, I don't know. I don't know how you can, I don't understand your definition, how you're reading the statute. I mean, there's a reason here. It's here to make sure that this is done at a very high level.
correct.
You know, that's one of the protections, the very highest levels of an agency. And I thought ICE was part of the Department of Homeland Security agency. Is that right? Do I have the flow chart right?
That's right, Your Honor.
Okay. They're not their own independent agency. Nor is Customs and Border Enforcement. I mean, they're components is what they are of the Department. If I go to Department of Homeland Security, am I going to see ICE like under the lots of boxes and ICE will be under there somewhere
Yes,
as part of the agency known as the Department of Homeland Security?
yes.
So it doesn't qualify under the statute unless you've got a definition of agency. And I could have missed something. These tax laws, there's a lot going on here. Is there a definition or a case that says for purposes of this statute, ICE or one of its predecessors qualifies as an agency?
Candidly, Your Honor, I do not know the answer to that question.
But it seems like there's a potential serious gap there because I think for obvious, when statutes say who may ask, there's usually a reason for that.
My understanding is that the government has, or IRS has gone through a comprehensive review of the legality of these requests and in fact rejected a previous request from from ICE when the signing head of the, whoever signed the original request for data was not a high enough official. So the government's position is that Todd Lyons as head of ICE satisfies the requirement
I
to
understand
receive
that
that.
you all are doing it.
Right.
I mean, you all briefed the thing that this is the same as the statute. I'm just asking for what that legal argument was when I see Congress being very careful about who can make. These are serious requests for obvious reasons. I mean, not just for privacy interests, but this is the blood of the federal government is revenue. And you don't want to do things that are going to impinge on revenue collection for obvious reasons. And so it's strange to me that there is no argument in the brief, no analysis as to how ICE qualifies. Like when they had, they have like subunits, like the administrator of the Drug Enforcement Administration, but they don't have any subunits within DHS or one of its predecessors.
Your Honor, the government on this point, unfortunately does not have a particular response to that, but I would maintain that the agency.
5E, and this could just be, let me ask and start a question, might make this easy. Is this MOU modeled on, put aside the opening stuff about executive order, but all the operative terms, are they modeled on an IRS form that, when people want things, they fill out this form and they make all these promises about, because there's things here about procedures and things like that, is that unique or is there some form that this was modeled on? Because that might solve some of my questions about how this works.
I believe that the MOU tracks the terms of 6103I2 and also in terms of the protection of the data once it's sent over is modeled after publication 1075 that describes the various procedures and policies in place to make sure that any disclosed information remains confidential.
The MOU is not with ICE, right? the MOU is DHS?
Correct.
Yes. But then,
And it's the Secretary of DHS that executed the MOU.
Correct.
Right.
but then said, here's how this is going to work. ICE will make the requests. That's 2A. ICE will make the requests. IRS will respond to requests from ICE. But the statute says the secretary will respond to requests from and then lists the entities. So I don't think it matters who executed the MOU. The MOU said DHS isn't going to send in these requests. ICE is going to.
What's happening with the requests?
Currently,
Yeah, well, how are the requests articulated?
I'm not sure I understand what you mean
Who
by
sent-
articulated.
Who is the ICE, is it ICE that's sending a request as a component of, in their capacity as part of DHS, because DHS, the Secretary of DHS has given ICE the authority to ask for a particular item, or how is a request under this MOU actually happening?
The request is authorized pursuant to the MOU between DHS and IRS, and following ICE, assuming a appropriate official signs over the request, ICE sends the request to the IRS. And then the IRS sends, if it complies with the requirements, sends the information back to ICE.
Okay.
Okay, but is there any ambiguity in 2A? That upon receipt by the secretary, this is Treasury for behalf of the IRS, which meets the requirements, a request from the head of any federal agency or inspector general, or in the case of the Department of Justice, lists some Department of Justice entities, director of FBI, administrator of DEA, any U.S. attorney, any special prosecutor appointed under, and there's a particular provision there, heads of criminal strike task force. So Congress has said where the request has to come from. This MOU says the request is not coming from the Secretary of DHS or anyone else on this list. The request is coming from ICE, and the IRS will respond to request from ICE, full stop.
The request is coming from ICE pursuant to authority granted by,
Is there anything in the statute
DHS.
that lets sub-delegations like that?
I'm not sure, Your Honor.
There is not. I mean, Congress knows how to say that. It'll say all that all the time when it wants to allow a delegation of authority further down the chain. And it seems like Congress right here was very careful not to do that. Then the releases to officers and employees of such agency who are personally and directly engaged in preparation for a judicial proceeding, an investigation that could result in such a proceeding or grand jury. How is this personally and directly engaged in showing being made when you're getting requests for 1.28 million
Well,
addresses?
the request was made for 1.28 million. As of now, only 40, I believe
That's not my
47,000.
question. Right.
Even if,
How is that being, I'm just curious, there may, I mean, I don't know, it's.
I mean, the
I didn't see in
individual,
record
sorry.
There's a form request that I can look at.
The individual who is investigating the 1.28 million is a high-level assistant director, and it's at the earliest
That
stages
person
of
is
a criminal.
personally and directly engaged in the investigation.
Yes.
What does
The-
personally and directly mean here?
I mean, at this stage of, the very beginning of a aggressive criminal investigation, for a crime like the willful overstaying of a final removal order, the beginning of that investigation may look like a large spreadsheet.
So, but I'm sorry, I'm confusing things here. It's my fault. I'm talking about to whom the information is released. Right? That's where they're personally and directly engaged in. Right? So there has to be a showing that the information will be released only to officers and employees who are personally and directly engaged. Is there something in the MOU that does that? That ensures that when the information comes back, it only gets channeled to those involved in that individual's criminal investigation?
Yes,
There's that.
the,
Sorry, there's a lot in here. I could.
No, no
just
worries.
Something.
in section 6 of the MOU, it describes the duties and responsibilities of ICE, which include keeping that information exclusive to people who are involved in that criminal investigation.
But then E says ICE will use and redisclose the address information. And I'm just wondering, how did I take it out of this case? I just don't quite know how this is normally done and then how it's done here. Before all of this, when a request comes in, do those requests usually identify the individuals to whom the information will be released?
And here, I believe the information is being released.
I'm just asking a question about, is that normally, do they list like names of the agents? I'm not even talking about this case.
yeah.
A year ago.
Right, let's say.
I don't know what they look like. That's why it's hard to know.
Yeah, if a single U.S. Attorney's office were making this request for a bank robbery, I imagine that it would be sent to the individuals investigating that particular bank
The
robbery.
U.S. Attorney would send it to, and would the request identify to whom it's going to?
I'm not sure, Your Honor.
Are there other MOUs with folks that are, I just don't.
No, the MOU, I think, is a solution to a problem that may have occurred if you tried to do large-scale criminal investigations with individual agents all requesting from individual IRS agents, and the information being spread.
Individual agents can't request.
But
So that's not.
then sending up individual requests to the appropriate agency head to send over to IRS, which would involve perhaps a greater risk of diffusion of this confidential information. The MOU streamlines that approach.
No, I think the whole point is that's why I'm asking. I guess my assumption reading the statute, if you say we're compliant with every provision of the statute, would be the right person would send in the request, and a listed authorized person would send in the request. And then would say what information they want, and its connection to proceedings, investigations, grand juries, and to whom the information should be disclosed. Right, the secretary shall disclose return information to. And so the request has to say to whom this information is going, and the only people it can go to are people who are personally and directly engaged in that. I assume in this case is investigations, or maybe it's proceedings too. I was assuming not grand juries, but you can tell me if I'm wrong. So that's what the statute says. So the only way the Secretary of Treasury would know to whom to release this information is the identification of individuals, the individuals. So a U.S. Attorney situation would say, please release this information to AUSA X, AUSA Y, maybe FBI agent Z, because they are personally and directly engaged in this investigation proceeding in grand jury.
And
How does that happen here when someone sends in a 1.28 million?
my understanding is that the individual who sent out that request is personally and directly engaged in that investigation.
So the person who makes the request doesn't have to be personally and directly engaged. I think it would be a lot to imagine. I think personally and directly means something more than I'm the head of the agency. I don't think Congress was assuming here that.
No, I'm sorry.
The Attorney General was personally and directly engaged. So I'm assuming the head has to approve the request. That's why the list is here. And then they say, don't bother sending it to me. I get so much about paperwork. Send it directly to ABC.
I'm sorry.
So what do these requests look like?
I think we're confused. I mean, the individual who they're sending I'm not talking about the head of the agency request. I'm talking about the assistant director who is listed as the person who's personally involved. I believe his name was Jeffrey Williams in the reporting, but he is the individual that the information sent to.
So his name is on every single So when there was a request for 1.28 million, his name was the person, listed as the person to whom
Yes.
the information should go. And he was personally and directly engaged in investigating 1.28 million people at that moment.
Yes.
Okay.
Hey, can I ask it, and just, I think it's related to this. There's this implementation agreement that's referred to in the materials that's in the record, but not in the appendix.
Yeah, that's,
Is some of this spelled out in the implementation agreement, how the mechanics of this work?
the implementation agreement is the kind of highly technical modes of data transfers. So yes, I think that the implementation agreement outlines some of the finer details about how this works in practice. And I would just say, and I apologize for not having the exact details on this, the conversation reflects kind of a larger difficulty with this case in that it's a pre-enforcement preliminary injunction. So the record before the court is really the MOU, the statute, and what was before the district court. So it's difficult for the government at this stage to explain exactly how this is being enforced when the lawsuit is challenging pre-enforcement.
Well, yeah, I mean, these arguments weren't being made, but they're still foursquare in the statute. So,
To the extent you're arguing the MOU is consistent with the statute, that's why I'm asking, that's the argument you made. And it's, I'm not sure it's you all are processing these things already. You told me about 4,000 you'd already turned over. So that's why the questions about what this looks like and how they're showing it doesn't seem like something the government can't know at this stage.
do we have an example in the record of an actual request and response under the MOU?
No.
Can you tell me again, just so I make sure I'm clear on it, what's your response to the appellant's claim, excuse me, that a court order is not necessary to get a mailing address under 6103.12?
Well,
One of their claims is this can't be done without a court order.
I think that claim contradicts the plain text of 6103 I2. 6103 I2 mandates that pursuant to a non-tax criminal investigation, if a requesting agency sends over a valid request, that return information and a taxpayer's identity is sent over, there's no mention of a court order in that.
But you're saying the
provision.
other statutory references to which they are pointing are irrelevant. I think they're citing some other provisions.
Right, other provisions. So for example, I believe 6103 I5 refers to locating a fugitive. One, that occurs only when there's an outstanding arrest warrant for an individual. And 6103 I5 allows a requesting agency to obtain far more information than 6103 I2. So each of these provisions represents kind of the balance that Congress is putting out between law enforcement efficiency and the confidentiality of a taxpayer's information. There were different balances struck in I2 than there were in I5. I5, they deemed a court order necessary, and I2, they did not.
What do you think under I5 is the most useful information?
It's hard to say. You can get the.
Is it? I mean, is it that hard? I mean, it does seem to me that under I5, the most useful information to locate a fugitive would be where they're located.
If they're being truthful with their returns in terms of their address, then maybe. But if not, then the employer's address might be more useful, or information about their bank may be more useful. I mean, it's hard to say exactly without knowing the specifics of that particular investigation.
And I also wonder with respect to I5, is the theory about how the information is going to be used by ICE/DHS/ICE, is it that the location is to find the person, or is it that the location is relevant to establish the 90 days, or both?
I think it could be both. It may be
because one of them would apply in the general fugitive context, the other one would not.
Correct, but under at least investigation into the willful overstaying of removal order, the location is useful outside of its locating properties because of the elements of the crime being investigated.
Can I ask another question? That is, my name is not particularly common, but there's a lot of people that have pretty common names. So if John Smith, so if you get a request from, assume it comes from someone authorized to send it for John Smith at 333 Constitution Avenue. And that's the latest address the requester had, but it's been a while. And you run the search and there has to be an awful lot of, and that's the only information they've given you, name and address. There has to be a lot of John Smiths with different addresses. How do you not mistakenly turn over to the law enforcement agency the wrong John Smith? Or if it comes in and you've got multiple responses, you just say, we can't. Would that be a non-response then? You can't respond.
I believe that, or I don't believe it's true, that in order to get the information from the IRS, there has to be an exact match with a name, either a name and an address that they have on file. So for John Smith at 333, at some point, the IRS would have to see a John Smith who also put a 333 down as their address, or an exact match between John Smith and the ITIN number that they were using to file taxes. So
But they're not providing an ITIN number, are they? When they request? I mean, that would definitely narrow things down.
I believe that there are terms under the request that you can get an exact match either for the name and address or the name and the ITIN number.
Right. I just wasn't under the understanding that maybe they have the ITIN number from something else. That makes sense if you have an ITIN number, but if you don't, and if it's not 33 Constitution Avenue, but it's a very large apartment building in New York City.
Well,
And you end up with lots of John Smiths that either currently or previously name and address matches. That's one thing that seems a little worrisome when someone just says, I've got a name and maybe an outdated address and I'd like to get.
So a couple things. First, I don't know how many real overlaps there's going to be between specific apartment numbers and someone's name and address that they had handed over to the IRS. For the purposes of this information sharing agreement.
There's a lot of people filing a lot of tax returns over a lot of years. And if you have common names,
well,
Maria Flores.
Let's assume that there would be a ton of, let's call it repeat names that are going to be overshared. The important part of the agreement is that they're being sent over for purposes of.
No, I don't want my name sent over if I'm not the right person that they were asking for. That's why I'm trying to understand how you can very easily imagine more than one John Smith having lived at some point in the records of the IRS, even in the same apartment, in the same large apartment building. But that's not the address. They provide a stale address. You've got a more recent, you've got lots of more recent. I mean, you're just going to be, I don't know how you protect people whose information shouldn't be turned over.
I think we've been operating under the name and address sharing information that we're talking about. But in the reality under the sharing that's going on now is unless DHS sends over name, address, immigration court case number, date of final removal, they're not getting anything from IRS. And so I get the.
Your records are only going to, I'm assuming you don't have records that are going to have those last two things. And so what you're going to be trying to match to is name and address.
But IRS will not process the request for name and address unless they see name, address, immigration court case number, date of final removal order, statute that's being investigated, and specific reasons why the location is relevant. So
when you pull up a tax return that says John Smith X address, I'm assuming nothing on that tax return or all the other files you have on that person are going to have anything about an immigration proceeding. So I don't understand how that narrows down what your response is. So I understand what you're saying. I mean, you're complying with the other parts of the statute. They have to say what they're investigating
Right.
inside the statute. I'm not disputing that. I'm just assuming they've done a proper request
Yeah.
and you get lots of responses with that common name for that common address. Is that the end of it? Because you can't match it?
Assuming that the request has already gotten through the door with
It's met all the it's checked all the other
multiple other
boxes.
requirements to make
Yeah,
sure
it's
that
checked
we're
all
the person we're
no, I
talking
mean,
about.
the person requesting has all that information, but all they've got is a name and an address. It's a super common name and a super common address. Because it sounds like you're searching all IRS files back for I don't know how many years. And so you're going to get 3 John Smiths at that address. What happens then?
If there are,
Or who at some point lived at that address is what I should say. I'm just wondering what protection is there for the taxpayer who is
I mean,
not the immigration enforcement John Smith.
the protection there is on, I guess, let's say that there are duplicates. I'm not sure if there's a specific protection against, that we got 3 hits on this, so we're going to run it down further. I'm not sure about that, but there is protection that the information remains confidential the entire time that it's being used by ICE. And as soon as it's no longer being used for a criminal investigation, they have duties to destroy or return it.
That address now, I'm going to have law enforcement breaking down my door.
I would assume not, because ICE would have.
But ICE will have all this return information about me because the search doesn't do anything to differentiate. I had thought if you had multiple returns, it would be we can't tell. We don't know whose information to turn over, but it sounds like your answer is if we've got multiple people with that name and at that address at any point in their history, you get all their return information and you leave it to them to sort it out.
I am not representing that there's not some procedure for dealing with duplicates. I just don't know one way or the other at this point, but I
mean, that's almost inherent if they're giving, assuming, and maybe they have the more recent address and you have an older one. I mean, it could be either way, but if assuming they're giving you the last known address to them and assuming that you have the more recent one, that's gonna, I assume you're going back and I don't know how back your files, how many years back your files go for, your records go for.
I think if there's an address hit, there's an address hit, and I mean
That's what Congress wanted? Wow.
the statute says that if you send over the address, IRS will send over the address that they have on file that matches that name and address.
Okay.
Your Honor, if I may just give a factual clarification here, in terms of the way the IRS is processing these requests. The IRS is only responding and providing address information to ICE if there is either one of 2 things, either an exact hit on the ITIN and the name, or an exact match on the name and the address. And that's an exact match. That's not Brad for Bradley. That is an exact match on both ITIN, because in many cases, ICE actually does have the ITIN of these individuals.
Mm-hmm.
That's actually the majority of the addresses that have been provided is where there's an exact match on both the ITIN and the name. If there is not an ITIN provided, then the IRS would instead search by name and address. And it's only going to be if there's an exact match on both of those things that there would be.
But when you say exact match, sorry, thank you, that's helpful, but one is helpful to know about the I-10, so that's a lot of them. I didn't know they would have those. And then 2, that name and that name has been associated with that address at some point in that taxpayer's history. Or only if it's the top address.
That's correct. There would be an exact match, and it could be for a prior tax year. It wouldn't have to be the current year address. That's
the
correct.
concern that I'm wondering about.
Yes, Your Honor, understood.
Okay, thanks. I mean, I appreciate that you're trying to help. Let's not have people just coming up to the podium and starting to speak without asking for the ability to do that, because that's not normally what we do here. But I appreciate that you're trying to be of assistance.
I see my time is up. If there are other questions, I'm happy to answer them.
Do you know what I don't want to stop the line of questions.
I'm just glad I have an uncommon name.
I know the feeling.
My husband does not, so I don't know what's happening with his documents.
Do you know the purpose of I2C?
The purpose of,
Why was there this determination made that taxpayer identity is something that needs to be carved out and should be turned over when tax return information generally would not be? Why was that determination made in 1970?
the purpose, not to get into the minds of legislators back then, but the purpose that is kind of obvious from the terms of the statute is there's a balance between confidentiality and law enforcement efficiency. And in weighing that balance, the taxpayer identity fell on the side of law enforcement efficiency, unlike other types of taxpayer return information.
So your view is that I2C actually was affirmatively intended to make sure that the law enforcement agencies the requesting agency had a current address so that they could use the current address for criminal investigative purposes?
I wouldn't necessarily say that it's the purpose to send over the current address, but to send over the address that the taxpayer had most recently sent to the IRS. The purpose of the carve out for that information is obviously to aid in the investigation of non-tax federal criminal violations.
Because that might be germane, because the address might be germane to the criminal investigation?
Correct.
You don't think it was because, okay, because there's some allusion to legislative history, and it doesn't look like that snippet of legislative history relates to actually making sure the law enforcement agencies have the address so they can use it for criminal investigative purposes. Now, it may be that the upshot is still that can be done. I am not saying that it can't be done. I'm just saying that I guess I wasn't aware that the reason that I2C was enacted was specifically to make sure that the requesting agency has the address so they can use the address for criminal investigative purposes.
I mean, it's located in a section of the tax code that is for the purposes of aiding in non-tax federal criminal investigations or
Right.
proceedings.
So in other words, you think it should be read that way because it's in this provision and that's the best inference from the text alone. I was just wondering whether there's something we know about the way this text came about that would shed additional light on that, but perhaps not.
I don't believe so, Your Honor.
Okay.
Can I ask one more question?
Yeah, of course.
Sorry. This phrase personally and directly, do you know if there's anything in the statute, in a regulation, manual, something that define, because the statute's been around quite some time, or case law, case law that defines what personally and directly means?
I don't know of any further guidance on the meaning of that phrase. I think it's pretty plain that it's someone who is.
I don't think it's all that plain.
Is someone who is investigating criminal violations.
Okay. That's all.
There's no further questions. Thank you,
Your Honors.
Counsel. Mr. Joshi, we'll give you 3 minutes for a rebuttal.
Thank you, Your Honors. I'll just make a few brief points. First, I would like to draw the court's attention to 6103M, simply because there are various provisions in there which show Congress is very concerned about disclosure of taxpayer address information.
So you said M is in?
Mary. Especially subsections.
Say Millett to make me feel good.
You asked about the implementation agreement. At the time, this case was before the district court. The implementation agreement was not in the record. It was still under seal. It has since been disclosed, and it has been posted in the docket in the Center for Taxpayer Rights litigation before Judge Colacatelli. So that is public now, if you're interested in that. Counsel mentioned that the IRS requires an exact match of the address. That I don't think is either in the MOU or the implementation agreement. And I'll point to page 54 of the government's brief where they say Even if the memorandum were rescinded tomorrow, the IRS would still be required by statute to provide address information to ICE upon receipt of a valid request. So the government's position is the MOU is sort of window dressing, but it's really the statute that's doing the work. And under their interpretation of the statute, they would disclose address information in bulk upon request. And so it's not just limited to orders of removal. Statutes such as the failure to register, reentry after removal, other criminal statutes. A lot of these criminal statutes, the difference between innocent conduct and non-criminal conduct and criminal conduct is a willfulness requirement. And DHS or ICE or whoever's responsible for asking for this information doesn't have to prove to the IRS there's evidence of willfulness. They will say, and the IRS won't question, we are doing this investigation for these types of crimes, and if that would be sufficient for them to get location information of taxpayers in bulk. So there's no real limiting principle if they're allowed to implement I-2 in the way that they have announced that they will do in the MOU. And I will say the other point about data errors, when there is the traditional situation where the prosecutor sends a one-off request to the IRS. There's communication back and forth. I'll point to our brief at page 40, which notes that up till this year, all of these requests have involved prosecutors seeking information under I-2. And when you have these sort of mass process requests that are not looked over by an individual, you do run the risk of some data errors. I'm out of time. If there's any other question, I will be happy to answer them.
Yeah, we can. The implementation document, you said it's in the record in that other case.
Yes.
I think you can just introduce it into the appellate record in this one.
I'm happy to follow that. Yes.
Okay. Thank you,
Thank you.
counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court now stands adjourned until Monday, November 6th at 1:30 p.m.